We hope you liked this video. And thank you for subscribing.
TDIU Extraschedular Claim Under 38 CFR 4.16b. While the Veterans Administration is at times rather good at assessing disability ratings, there are a number of situations that do not fit neatly into numerical categories. For example, a veteran might sustain a leg injury that causes a gait disorder and a back injury. Total disability due to individual unemployability claims are another example. These claims are inherently subjective. Essentially, these veterans have partial disabilities which are so severe that they are tantamount to total disabilities, even though the rating schedules used may not produce a 100% disability rating. TDIU is another way a veteran can obtain disability payments, as though his or her rating is set at 100%. In most instances, the veteran must meet certain rating criteria in order to be eligible for TDIU. Veterans must have a 60% disability, or a combination of conditions which total a 70% rating with one of the disabilities assigned at least a 40% rating, along with unemployability. What if veterans do not meet ratings criteria? Even if a veteran does not meet the ratings criteria for a schedular TDIU claim, a Veterans Administration disability attorney might be able to obtain TDIU benefits via the extraschedular approach. Unusual symptoms. Most veterans have either physical or psychological service-related disabilities. The rating systems in both these areas do not account for unusual symptoms. To rate a physical disability, many compensation and pension doctors rely on range of motion tests. That is especially true in the knee, shoulder, ankle, and other joint injury cases. The less motion in the joint, the higher the disability rating. This approach does not account for individual disability factors, such as unusual pain. For example, a veteran's ankle might have a stiffness that causes inflammation, which makes it impossible to stand for more than a few minutes at a time. PTSD nightmares are a good example. Some people have disturbing nightmares. Other people have such graphic nightmares that they are afraid to go to sleep in the first place. The lack of sleep can cause compounding difficulties that may not be properly accounted for in the assigned rating. A non-professional person's testimony often helps establish unusual symptoms. Friends and family members, even though not doctors, can testify as to how a disability affects a particular veteran. Typically, a non-professional person's testimony is quite compelling in its simplicity. Frequent hospitalization or employment interference. There is no hard and fast rule as to what constitutes frequent trips to the hospital or a substantial interference with employment. A veteran with an ankle injury might be in and out of the hospital quite a bit, mostly due to falls. Most employers are quite patient with disabled veterans, but their patience is not unlimited. At some point, the hospitalizations will become too frequent. Supportive, expert testimony. When a non-professional person's testimony regarding unusual symptoms or effects is insufficient, veterans must supplement this evidence with expert testimony. That is especially true if the veteran has a limited work history. Many attorneys partner with vocational experts. These individuals consider not only the medical and psychological effects of a disability, but also its impact on vocational prospects. Contact dedicated attorneys. Regardless of your percentage rating, total disability benefits might be available. For a free consultation with an experienced veterans disability lawyer, contact Cameron Firm PC at 800-861-7262. Or visit the website and fill out the contact box, www.veteranappeal.com. There is a link in the description. We represent veterans nationwide. And there is no fee until we win.
Thanks for watching. Drop a like, leave a comment, and don't forget to subscribe.